The PowerPoint card is on the iPad.
Is it on there? Yeah.
We should be live now.
Okay, welcome back, folks. This is, we're continuing our work
Yes.
on our justice oversight or joint justice. Justice oversight, what it used to be. So if we could close the door to the hallway, that would be great. So we're going to pick up testimony with folks on S7, which is the expungement and criminal sealing of criminal records legislation, which is now Act 58. And we are going to begin with the state's attorneys and sheriffs with John Campbell. And I know you brought the new.
Yes, yes, and I would introduce Evan Meehan to the committee. I'm not sure, I know some of you have already met Evan, and I don't recognize you at your glasses, that's what it was. Without, Evan is replacing James Pepper, who, as I believe all of you know, is now the chair of the Cannabis Commission. Evan will tell you a little bit about himself, but his background included chief of the criminal division for the Attorney General's office, and then he also was general counsel for Department of Natural Resources. So I'm not very.
I was associate general counsel for the Natural Resources Board of the Recidivism, and then I worked twice in the criminal division office on the bill.
That's what it's always better coming from yourself. For the record, John Campbell, Executive Director of the Department of State's Attorneys and Sheriffs. Peggy, we can just go right to the next slide. I just wanted to start off before I turn this over to Evan, just to let the committee know that we do support the issue of expungement, sealing, and again, semantics does matter here, which I'll go into in a second. But we do see the value in the fact that somebody has committed a crime, unfortunately committed a crime, made a bad decision, and years later they've shown that they have not repeated that or not had any other issues. Then we feel that they should have that opportunity to put that behind them. But we think it comes down to eligibility for which crimes we're talking about. And as you know, when S7 first came through, we discovered that there were certain crimes that I think were unintentionally included. The one that really stands out is the sexual, exploitation. Thank you, of juveniles or minors. And we brought that to the attention, and it was interesting. It's not that we knew that right off the top of our heads. It just shows you how convoluted these statutes are, because sometimes that they refer to them as cross-referencing them. So in order to do that deep dive, you really had to go through several statutes and see where the cross references were. So I don't think there's that somebody intentionally said, well, we're going to let all those crimes, and we want people who have who have sexually exploited children to be able to expunge their crimes. I think it was just that it was inadvertently overlooked. So. But as we got into it, as we did that deeper dive, we also found out that there were other issues that were coming up and that were being brought to our attention by our offices. So that's when we spoke with and went before the House Committee and also Senate Committee and explained our concern that we should probably take a longer, harder look at exactly what actions are being taken by the legislature regarding this issue. So our concerns are trying to figure out exactly who should be eligible for the crime, what types of crimes should be eligible, what type of criminal history might have been there as far as the individual who's applying for the expungement. Of course, the impacts also on the victims. That, to me, that's one of the more important things. You have to find out, how will this impact the victims and also our communities. And also rehabilitation, and then to find out if the crime that was committed was one of those that specifically can impact not only our community members and the safety, but also financially with some businesses, because there were some financial crimes that we were concerned about as well. And before I will turn it over to Evan now. However, two things actually I wanted to say. One was in response to Marshall's discussions about law enforcement and what they use the information for, if they use past convictions or past arrests. I would just urge you to ask that law enforcement testify before the committee to find out exactly, what they do have access to, why they have access to it, and how they use information. Just to make sure that everything is straight, where you get it right from the source, because there is the information that I had acquired by talking to law enforcement is that they don't have some of the information that people are saying that they do. And so I think it's extremely important that you do have them come in and testify and find out what access they have. The final issue is really knowing what the definition of between expungement and sealing. Expungement it's interesting. It's used in the 50 state. We gave you a 50 state study of the different laws, and they're often used interchangeably, which and they really don't mean the same thing. If you look if you check them out in the dictionary, expungement, we're talking about the total destruction of a physical record, whereas sealing is the records are still there, still maintained, but the similarity is the same. I mean, you can in the expungement process, if records are sealed or expunged, that person then can treat it as if it never happened. And so if they're asked for employment or for education or any of the other issues that we've talked about here today, they can say that no, that they have not been convicted of a crime, and that record should be treated as the same, with the exception that sealing, if you seal the records, then those physical records are always available at some point with whatever limitation you put it on, as to who would have access. And I think Judge Grierson had explained it pretty well in the fact that they have certain permission levels, and if you don't want people to get to that permission level to where they have access to it, then now with the new software, you'll be able to do that, and that they will not have authorization unless they go and seek a court order for that. So I'd like you just to keep that in mind, because our bottom line is, I think that if we go forward, if you go to sealing versus expungement, in other words, not the full destruction of official state documents, then you probably will be able to avoid many unforeseen consequences. And now, if you don't mind, Madam Chair, I'll turn it over to Evan, and he can go through some of those.
Great. Welcome, Evan.
Thank you very much.
Can I ask a question of John before?
Yeah, Senator Sears.
He can answer from that. John, one of the things that's troubled me about this whole process is that the Sentencing Commission made recommendations, and all the players were on the Sentencing Commission. And how did this happen? How did the idea that there were, that suddenly the work of the Sentencing Commission was undermined, or that's maybe a bad term. How did that happen? State attorneys were represented, attorney general was represented, the administration was represented, corrections was represented, and all of a sudden, all these questions came up as the House was working on S7. How do we avoid those pitfalls in the future when we as legislators rely on the recommendations of certain groups? And whether those groups be, a climate action council or a sentencing commission or whatever, you name it, the redistricting commission, all of those groups, the legislature relies on for information. We don't have the private staffs to do the work. So I guess fundamental question.
Senator, I think that's an absolutely fair question, and it's one where, trust me, I have my frustration with the Sentencing Commission as well. First of all, there was, if you look at the commission, it wasn't just the people that you had mentioned, but there were also outside other groups. We had a large number of people on that group. I believe that what you saw, what came out of it was, in essence, a compromise from, let's say, the state being on one side. When I say the state, as far as from our perspective, the state's attorneys and the administration. Whereas on the other side, you had members of the private bar, which were defense counsel. And again, nothing. I'm not casting any aspersions. I'm just saying that it was sort of I think, almost a recipe for disaster when you figure that all the people that you had in the room and trying to figure out of coming to some consensus that was going to be actually we would be able to deal with an issue that is so it can be very convoluted as to what exactly we're discussing as far as the type of crimes, the number of crimes. And we have over almost 1,000 crimes, I believe, on the books. And as you know, Senator, over the years, people come to us and say, why is this still a crime? Why are we doing it? Why do we have this on the books? Because there are crimes that generally are not charged, or crimes that people may not be aware of. And I'm not so sure if I don't think the Sentencing Commission went through the entire list of crimes and said, these should be expungement eligible. I think that they looked at a group of, they grouped them into different areas, and when they did the expansion, and there are some people who believe that any crime should be expungible, even the ones I just mentioned, as far as the sexual.
Well, I understand that. I just wanted to point out for the rest of the committee and for those that may be watching that the legislature trusts in certain outside groups to provide information, whether they be the Sentencing Commission, global, the Climate Action Council, etc. And when we do, this is problematic for us, and we have to figure out how we're going to deal with things in the future. And we don't, right now, this committee is being charged with this task because, frankly, we heard back from the administration and others how they did not agree with the Sentencing Commission recommendations. So the future, this is a special legislative committee, joint legislative committee. And I am worried about the future as these commissions and other groups are appointed to provide input on whatever the topic is to the legislature. And then this is concerning to me. So I just wanted to raise that. I'm sorry for picking on you, but I know you well enough to know that you understand when I pick on you.
Of course, you've never picked on me before, but
Never.
Again, let me just say that I think what you're saying is fair, because I don't think that the legislature received the information that they should have had. But again, I'm not saying that the commission intentionally withheld this information. I just don't think that they did the due diligence, and I will take part of the responsibility because we had a seat at the table also. So we failed as well. And I'm just happy that we ended up taking a long, harder look before this bill was passed, because I think what's happened demonstrates that there were issues that were not brought to your attention. And that should not be the case. And when people, if you're going to talk about stories, we should have factual issues here, because that's what you should be dealing with, facts, not just supposition, not just anecdotes. We need to have actual facts as to what really is happening out there and who can really be affected by these laws, because there could have been some real damage here.
Welcome, Evan.
Thank you very much. And just for the record, again, my name is Evan Beanon with the Department of State's Attorneys and Sheriffs. And Peggy, if you could please advance to slide 5, I would greatly appreciate it. So slide 5 is an overview of some of the issues that the department has identified since Act 32 expanded opportunities to obtain expungement and sealing of criminal records. Yes, that's exactly the slide. And, you know, some of these issues maybe perhaps even went previously unidentified or underappreciated because the volumes of expungement limited the number of opportunities for us to identify issues. But now that we're seeing more of these petitions, we're able to flag things that maybe are of concern that we didn't realize before or of greater concern. In the interest of time, I'm going to highlight the biggest issues that we would like you to pay attention to, but we are happy to come back at any time and discuss them in more detail and answer any more questions. Next slide, please. So the first issue in the department's position is probably the most important, and it deals with the ways in which the expungement of records, in other words, the deletion, the destruction of them, can compromise prosecutors' ability to comply with their ethical obligations and can also compromise a defendant's due process rights. So the rules of professional responsibility and the Constitution obligate prosecutors to disclose to defendants exculpatory information that might undermine the validity of the accusations against them. Exculpatory information includes information related to a witness's or a victim's credibility. So I've outlined 2 hypotheticals here that I would appreciate your consideration of. The first one I'll flag, though, is not actually a hypothetical. This is an issue that's been brought to my attention since I joined the department and is one that one state's attorney is currently battling. And right now, we're not confident if there's a way around it, and the end result may mean no criminal charges are filed because we do not have the information anymore related to a key witness's, a victim's credibility in order to produce it to the defendant. And we are statutorily obligated to represent that no records exist. We cannot disclose it to the prosecution. Interestingly, a third scenario, which did not make it onto the slides because it came to our attention after the fact, involves a recent motion that was filed in Caledonia County by a public defender. This was a domestic violence case in which charges were filed against both the alleged perpetrator and the alleged victim. The alleged victim's charges were eventually expunged. And the result of that was that the alleged perpetrator, who was still facing charges, filed a motion to dismiss. And the allegations in the motion to dismiss are: judiciary, you ordered that the victim's records be destroyed. State, you complied with that order and destroyed the records. Now I, as the sole remaining defendant, no longer have access to potentially exculpatory information. The only ramification is you must dismiss the charges against me. So what we're seeing in some of these fact patterns is what may be good for one defendant may be bad for another defendant. And what may be good for a defendant, another defendant might actually use as a sword to defeat the charges against him or her. These are the types of issues that we're starting to identify that perhaps went previously unnoticed or underappreciated. If you could please advance to the next slide. We've already heard mention how some defendants may want access to their own records that might have been destroyed. And we also heard some indication that perhaps the special index that the judiciary maintains may be sufficient to serve those purposes. But as the situation I just described with the motion to dismiss in the domestic violence case, that special index does not solve the problem. It did not give that defendant access to, for example, the victim's previous statements to law enforcement, any recordings of the interviews of her, or any of the information that the defendant might wanted to have in order to evaluate whether or not the story the victim was giving was the true story. This is another hypothetical, or actually it's not a hypothetical, this is an actual case that I handled when I was a prosecutor for Bill Sorrell in the Attorney General's office. I can only cover the case very peripherally because I'm obligated to represent that for the most part this never happened. But what I can tell you is we were prosecuting a defendant who received a deferred sentence. A deferred sentence results in an expungement, but through a different mechanism. The defendant completed the terms of his deferred sentence, and as I was required to do under law, I destroyed all records related to his conviction. The defendant was also facing a license revocation proceeding brought by the state of Vermont that related to the incident giving rise to the deferred sentence. He thought that there might be information in my file that would be helpful in him getting his license back. He submitted a public records request to me asking for those records because he thought they would be helpful. And I had to tell him, I don't know what you're talking about. No records exist. And he did not get any of the records, even though they related to conduct, which he knew about and I knew about, and which was resulting in the revocation of his license.
If I could just stop briefly there. Am I right, though, that he initiated his expungement?
Well,
So it was the consequence of his own action?
well, yes and no, but I think at the same time,
Well, isn't it? Yes?
well, yes, but what we need to question is, did he know what he himself was getting into?
Well, that's a separate question.
Right.
Yeah, so in other words, as a reasonable adult, he put in a request to have an expungement. He may not understand all the, I assume he put in a request.
No, not necessarily. And this is why a deferred sentence is an alternate mechanism for leading to an expungement. When someone successfully completes the terms of their deferred sentence, the expungement basically happens on its own. To call it automatic is maybe a little misleading because it does require a prompt from the court. You need to know that the deferred sentence was completed, but it doesn't result in any additional petition that the defendant needs to file. So the defendant knew that an expungement was on the table at the time that he agreed to the deferred sentence. But did the defendant have an awareness that if he wanted to, if the contest over his license revocation was going to last longer, in other words, he was in a race now, he needed to find a way to get his license back before the expungement happened if he wanted to be able to retain, if he wanted to be able to get access to my file as the state's file, in other words. But you're right, to a certain degree, if a defendant no longer has access to their own records, maybe people should say, well, that was on you. You asked to have these records destroyed, and now you need to live with your choices. But we also need to remember that this whole exercise is about the degree to which people need to live with their choices forever, right? So someone, got themselves in trouble and they committed an offense. But we're saying, let's not force them to live with that choice forever. Let's find a way to give them an opportunity to rehabilitate themselves. And in this particular situation, if the individual had been rehabilitated and wanted his license back, well, he had a diminished capacity to make that argument. Whether he should have realized that at the time he entered into the deferred sentence, you could certainly make that argument. But as the previous hypothetical that I gave with the motion to dismiss, sometimes it's not the defendant who's having buyer's remorse, it's another defendant using someone else's expungement as a tool for their own advantage. So there are layers of complexity here. And as I said, some of these issues may have gone underappreciated or unappreciated. Next slide, please. I'm not going to spend a lot of time on this slide. This information has been previously provided by John Campbell, and it addresses the massive amount of resources that can sometimes go into complying with these orders. And I would just encourage the committee to give that some thought as it deliberates. Next slide, please. One of the things that I've noticed since joining the department at the beginning of May was how much the state of Vermont has done in the 3 years I was working at the Natural Resources Board to reform criminal justice in an effort to reduce recidivism. And I do think for the most part, that's something that most Vermonters should be proud of, and many of them probably are. But when we talk about expungements, I think we really need to be clear about what we mean by recidivism. In the state of Vermont, there is one definition of recidivism contained in statute that I was able to locate, and that is repeated in full on this slide. And I think it's important for folks to realize that under this definition of recidivism, it is technically possible for recidivism rates to go down while crime rates remain the same or even go up. And so if we're going to be tracking the effect that expungements can have on recidivism rates, I think we need to be clear when we have these conversations about what we mean by recidivism so that we can make educated decisions as policymakers, and so that Vermonters, when they hear this data, that they appreciate what exactly it means. The next slide, please. can actually advance to the next slide as well. Thank you. Now, this committee is charged with answering a few key questions. Some of those questions are, should all criminal history records be eligible for expungement? Should both expungement and sealing be options? And should expungement and sealing be automatic? In order to help the committee answer some of these questions, what we did was we located it was called a 50-state survey. Honestly, it's more like a 55 jurisdiction survey. It's every state in the union, as well as the federal jurisdiction, and some US territories such as Guam, Puerto Rico, and the District of Columbia was included as well. A copy of that 50-state survey has been submitted to this committee. The survey itself does not answer some of these key questions. So that is why we attempted to synthesize it in the spreadsheet that's also been submitted on gigantic paper for you. And we organized that in a way that would hopefully shed light on some of these questions. Next slide, please. This slide attempts to summarize the summary of the survey because, as you can see, this is a really complicated, complex issue. But this is what we have surmised. 41 out of the 54 jurisdictions, and I'm excluding Vermont because we know what Vermont does. So 41 out of the remaining 54 jurisdictions appear to seal records only, even when they use the words expunge or expungement. And when I say that, I'm defining seal because not all of those 41 jurisdictions even use that word. They might use expungement. So when I say they require sealing only, what I'm referring to is anything less than the mandatory total destruction of the underlying police and prosecution records. Only 17 of the 54 jurisdictions appear to have any form of automatic expungement. I will say that there were certain types of convictions or offenses that seemed to be most commonly included in the automatic process. They were things like marijuana convictions in jurisdictions where marijuana is no longer criminalized, prostitution-related convictions for victims of human trafficking, convictions which have been pardoned, or defendants who have received, some type of reprieve through like an Innocence Protection Act or some other venue for proving your innocence through DNA testing. Two things that I want to note because we heard a little bit about a study from Michigan earlier today. Michigan is one of those 41 jurisdictions that appears to require sealing only. Michigan is also one of the states that has some form of automatic expungement. However, it is limited to a certain subclass of misdemeanor offenses. So there are caveats when it comes to those 17 to 54 jurisdictions.
Just briefly, so I'm looking at your bullet points. Is it wrong to assume that out of the 54, the rest have some form of actual expungement?
Yes, that is absolutely fair to infer. Yes.
Okay, and then my other question would be, is there a trend line in terms of, are people generally moving away from actual expungement, or is that a trend? I'm thinking about legalization of cannabis. I think that's driven a lot of this. Is expungement, actual expungement, on the rise or the decline?
That's a fantastic question, and I don't have the answer to that.
Okay.
I will tell you that I created this summary off of that 50 jurisdiction survey, and as the asterisk indicates, that was last updated in October of 2020. So there could even be some changes that have happened since then. But in order to answer your question, I think what you would really need to do is take a look at those jurisdictions, figure out the effective date of their expungement laws, and then figure out whether or not those had been amended. Right. That would be a very big task, but it's technically feasible to do.
Just wondered
yes.
if you had come across it.
No, I apologize, but unfortunately, I was not able to draw any inferences about that. 0 jurisdictions made all convictions eligible for expungement or sealing. There were some areas where there was a lot of discrepancy in approaches, a really wide range. And those had to do with when records were sealed, who was going to have access to them and how. Some jurisdictions, it was law enforcement could have access for any law enforcement purpose. Other jurisdictions said, no, law enforcement, you need to lock your stuff down and you can only get it with a court order. There's a lot of discrepancy there. Which convictions are eligible? There was a huge range of discrepancy, but I think we also need to appreciate that different jurisdictions have different crimes and they define crimes differently. So sometimes it's not always an apples to apples comparison. And then another very big point of disparity was, what was the impact of someone's previous criminal record and what was the impact of them committing a subsequent criminal offense? I will say, though, that most jurisdictions did not foreclose the opportunity to expungement just because someone had a prior criminal record or just because someone subsequently committed offense. Typically, that was not a deal breaker totally. It might have altered eligibility a little bit or altered the timing, but it didn't completely shut the door. Next slide, please. This is another slide I'm not going to spend a lot of time on because this is a huge topic. What crimes should be in and what crimes should be out. The purpose of this is to highlight on a very high level that there are some offenses that should be concerning, that are violent, and which the legislature cared enough to make criminal in the first instance. But they are not included on some of our existing lists of offenses, such as Big 12 offenses and listed offenses. And I think the department would encourage a good conversation about what offenses should be in and what offenses should be out. And it may be necessary to do a real inventory of what crimes are on Vermont's books. The next slide, please. This again is not a topic that I'm going to spend a lot of time on because I've already flagged that in most jurisdictions, subsequent offenses are not a total deal breaker. But I did want to flag this because it was a big topic of conversation at the end of this past year when the legislature was convening. I think everybody agrees at this point that the longer someone goes without committing offense, the less likely they are to commit an offense. And that is one of the justifications for giving folks an opportunity to have their records expunged or sealed after any given period of time. However, under some versions of S7, it was possible for someone to commit a subsequent offense and not actually lose their original expungement eligibility date. And this is a very simple hypothetical that attempts to illustrate that point. I'm sure I could monkey with the numbers and come up with other hypotheticals as well. Next slide, please. So another big topic of conversation was who should be able to stipulate that an expungement should occur. The purpose of this slide is to flag two things very briefly. The first is that some versions of F7 took different approaches to this, depending upon whether or not the petition was filed on time or the petition was filed early. For early petitions, it was the prosecuting office that had to stipulate or authorize another prosecuting office to stipulate. For timely petitions, any prosecuting office, either the AG's office or the state's attorney's office, could stipulate, regardless of their familiarity with the case or their relationship with the victim. And relationships between a prosecution's office and victims can be very important for some victims. Moving on to the final slide, I wanted to flag this as the last area that I remember having a significant amount of discussion towards the end of this past year. And that was, when should judicial involvement what should judicial involvement be in the expungement and sealing process? And this is one of those issues that we're sort of identifying as we start to work with more expungement orders. And it has to do with the impacts of a stipulation. The language right now in statute that says if there's a stipulation that that a criminal record should be expunged, then the court shall expunge it. What's not clear is, what if the parties stipulate to an expungement, but law enforcement, a victim, or the judiciary, in fact, disagrees that the eligibility criteria have met? Does the shall and the stipulation override that or not? Or can the judge still say, I question if the eligibility have been met, the victim and law enforcement has expressed concerns, and I would like a hearing on this matter? Now, with a lot of these issues, I do want to point out that we have 14 separately elected state's attorneys in the state. And we're hoping to have conversations about all of these issues so that we can come up with some workable solutions. We're interested in finding something that works because, as John Campbell mentioned, the department is supportive of expungement, but we don't have concrete solutions yet for all of these issues. We're hoping to work on that this summer and have some more information for you later on. And with that, I'm happy to answer any other questions, and I'm sure John Campbell is as well.
Thank you. Questions? Good folks? Let's see.
I know it's running late and I don't want to keep. But a number of issues have been raised by the state's attorneys. One of them is a basic problem that we wrestled with, and I would love to have you and the Attorney General get together and come up with some solution. You're having expungement days like the one that I forgot the date in Rutland that David Scher mentioned, but you're working together. That was why we did what we did. Now you guys need to come together and come to some solution on that one. Frustrating to hear that that's a problem when you all work together on these things. So hopefully you can recommend some things to this committee on that one.
Yeah, and I hope the fact that the Rutland County State's Attorney is working with Attorney General Donovan shows that we are attempting to work in partnership.
No, that's my point. You know, if 10 clients are there and 5 of them go to the state's attorney and 5 of them go to the Attorney General, that's the idea behind it, isn't it?
Yes, that is the idea, and those efforts are being made to work together like Rutland County, and so we are making those efforts. And I think for the most part, we're having some success, and I think that we are working cooperatively. But we have elections, and people change, and people's ability to work successfully with one another to implement the law is sometimes dependent on.
I'm just requesting, it seems to be an issue between the state's attorneys and the Attorney General, and I'm just requesting that you all come together and come to some solution on this.
Understood.
Other questions, comments?
Oh, thank you very
Oops,
much for your
thank you.
time.
Thank you. So we have Jay Johnson, General Counsel of the Governor's Office. So welcome, Jay. And then we have David Moore after that, and Sarah Robinson.
Thank you, Madam Chair. Good afternoon, everyone. I also am very happy to join you in person today. I am, for the record, my name is Jay Pershing Johnson. I'm the Governor's Counsel. I am happy to be yelled at by Senator Sears on the about face in the legislature this year. You know, it is a bicameral and presentment process. We testified in a committee, and you know, that's really all I can say about that. We had a difference of opinion on policy, and I think we made that clear. I do appreciate the opportunity, though, to testify on expungements in Vermont, and I do hope that this is the start of a continuing conversation. I think there is room to find accommodation on changes, and as has been discussed today, for the large part, you know, policy and processes. Senator Sears is correct. We expressed some concerns with S7. But we support the legislature's decision to review the issue of expungement more holistically. I believe, as with many criminal justice issues that we have faced recently, it's important to take a step back and take stock of our purpose and our existing laws and think about whether what we have is working and serving the purpose it's intended to serve. As discussed today, it sounds like there may be more effective alternatives available. And to the extent there are specific concerns about collateral consequences like housing, it's clear that we are working on innovative solutions to housing for the offender population. So I think that while this is an approach, there is more than one tool in the toolbox. And I think it's important to remember that there may be alternative approaches to some of these more specific collateral consequences. With respect to that, expungement in this context is variously described as relief for offenders from collateral consequences. It's a jobs bill. It's a means to reducing barriers to employment, housing, and education. But as we all know, the devil is in the details. The Office of the Attorney General maintains a database pursuant to our Uniform Collateral Consequences Law, which contains hundreds of state and federal collateral consequences, laws and regulations which impose collateral consequences on offenders. That can be found online on their website. So these were all arguably passed for purposes of protecting the public or a segment of the public. So one approach the legislature might consider is with respect to concerns with specific collateral consequences, taking a look at the body of work that you have created before you generally take on increasing the number of felony expungible offenses in order for those offenders to be generally relieved of collateral consequences. It's a very, very broad class of things. It's important to understand what exact relief we're offering to what offenders and under what circumstances. So, and these again are not hypotheticals, but pardon applications we've received. Should someone convicted of a misdemeanor possession of child pornography ever be a bus driver again? Should a person convicted of domestic violence or a violation of abuse prevention order possess a firearm? Those things are collateral consequences. Those rights are removed when you commit certain offenses. If that's the legislature's policy direction, however, we do agree with, I think, the statements of David Scher and Marshall Paul that one thing I think we understand, although we don't have good data, is that the people who are eligible or may be eligible for expungements aren't seeking them. If the Michigan data is any indication, that's about 6%. Maybe it's 10, but that's not very many people who may be eligible. David DeMora may be able to speak more to this because he's been doing a lot of data collection and analysis for the state. But our laws are already expansive in terms of off-ramps, expungements, and sealing. They're very complex as well. So Vermont's expungement laws are quite robust. One might argue that we already have a broad expungement regime in Vermont. And I've done an inventory of just the expungement laws that I'm happy to share. So there are at least 5 expungement laws for juvenile offenses alone. And these include automatic, and I'm using the term automatic, but Evan actually said it quite nicely. They're not completely automatic. There is some amount of court review for purposes of determining the interests of justice. But so I'm using the term automatic with that caveat. So these include 5 automatic expungements for successful completion of diversion and automatic expungement of qualifying crimes, which includes all nonviolent misdemeanors already, for the successful completion of the terms of a conviction. So for juveniles in the general expungements law in Title 13, no waiting period, just successful completion. They also include sealing the records of adjudicated delinquents. So and that's all crimes other than the Big 12, and sealing the records of all youthful offenders upon successful completion of the probation term. And again, youthful offenders can be in the family court for any crime. It just depends on whether the court allows it, the prosecution moves for it, but very often we're looking at offenders, many youthful offenders moving right into the family court. Those are expungible or sealed upon successful completion of the probation term, whatever that is. And we might never know because those are family court records. So again, this could be for any crime. There are an additional 8 expungement laws for adults, including automatic expungements for successful completion of adult diversion, successful completion of the terms of probation for a deferred sentence, which we've discussed a little. In the case of adult diversion, in the Tamarack program, so that's for people with substance misuse disorder or mental health related crimes, those are all crimes. Oh, no, I'm incorrect. Not all crimes. It's not listed crimes. So that's just something to keep in mind when we're talking about our system expungements. And now it's not doing enough or going far enough. I mean, what we really might be talking about is the issue of uptake, because we have lots of opportunities for expungement already. We know from the data and analysis of the Council of State Governments that the number of criminal cases filed with the state is fairly steady at about 15,000 per year. Of that number, about 78% are misdemeanors. So almost all misdemeanors, except for the most violent misdemeanors, are expungible now. So you're setting up a funnel. Roughly 20% of misdemeanor cases and about 10% of felonies result in dismissals and expungement through diversion. We also know that 99%, I think David Scher mentioned this, 99% of convictions are the result of plea agreements. All misdemeanor charges with convictions are convicted as misdemeanors, and approximately 40% of all felony charges are convicted as misdemeanors. And again, most misdemeanors are expungible. For juveniles, again, successful completion of the terms and conditions and 5 years for adults. In 2017, this waiting period was reduced from 10 years. So that is something significant that you have done in the last 5 years. So we know also from changes made in 2017 to the Uniform Law on Collateral Consequences that the courts are now required to advise offenders of the opportunity for expungement or sealing in pretrial proceedings and again by DOC at release. So if your goal is to reduce barriers to housing, jobs, and education, most Vermonters with criminal records are already eligible for expungements. And it would seem that maybe if we have, and again, we don't have the data to support it, a low rate of uptake on expungement, maybe we need to work on why Vermonters are not seeking expungements before we simply add crimes to the list of expungible crimes. And as others have mentioned, working on simplifying and streamlining our existing laws rather than piling on to our existing laws. Which again then gets me to where I was actually asked to testify on which listed crimes I would recommend for expungement. And if what we're really talking about is relief from collateral consequences for violent felony offenses, I think Vermonters should understand that this is our direction. It's important to note that the victims of listed crimes suffer significant impacts. That's why the list, where it's found, is in a law that's established for the benefit of victims. Some of these offenses result in death or injury, serious injury. Most, if not all, will result in a lifetime of trauma for these victims. So these are consequences suffered by victims through no fault of their own. And yet our focus today is on the consequences for offenders. You heard from David Scher, and you will probably hear from David Demora, that at about 7 years, the risk of reoffense is extremely low for all offenses. And I completely understand that. That said, it's my understanding that this committee is not considering Big 12 crimes, the worst kind of crimes. They also appear in the list of listed crimes. The AGO would add abuse of authority by law enforcement. But I think what's important to note is that everybody draws the line somewhere. Everybody has a feeling about what they feel the worst crimes are, and that may depend on what your personal experience has been. But I've been asked to testify on which listed crimes should be eligible for expungement. So I'm not going to list the Big 12, which are also in here. but that would include stalking and aggravated stalking, misdemeanor domestic assault, first and second degree aggravated domestic assault. Technically, aggravated sexual assault of a child is not a Big 12 crime, but I'm assuming it's lumped into aggravated sexual assault. I don't really know. It's a separate crime. Lewd or lascivious conduct with a child, recklessly endangering another person, violation of an abuse prevention order, operating a vehicle under the influence of alcohol or drugs with death or serious bodily injury resulting, careless or negligent operation resulting in serious bodily injury or death, leaving the scene of an accident with serious bodily injury or death, the attempt to commit any of the offenses listed in this section, elder abuse or other abuse or exploitation of vulnerable people, including restraint, neglect, sexual abuse, financial exploitation, and exploitation of services, and human trafficking and aggravated human trafficking. And I'd also note, it's not a listed offense, but required to be registered on the sex offender registry is a second or subsequent conviction for voyeurism. And Evan noted some other violent crimes that you might want to consider. So I have to say today, without more, and I see this conversation going in a number of directions, I'm not able to suggest any of the listed crimes be added for expungement. So thank you. I'm sorry if I took too much time. I appreciate your time and attention.
Thank you.
Any
Questions?
So Ms. Johnson, I see you have written testimony. It'd be wonderful if you could submit that.
Sure, I can do that.
to our-
I'll send it to Peggy.
Thank you.
Okay, thank you.
Any other questions?
Thank you.
Thank you. Thank you. Sarah, do you have to leave early? Okay, so let's go to David Demore and then we'll go to Sarah and then we'll finish up on this. So David, you are zooming in and if you're willing to weigh in on this, it's all yours.
Certainly. To be clear, again, David Demore, Senior Advisor with the Council of State Governments Justice Center, for the record. As I understand it, what I have been asked to talk about is the issue of the impact of expungement on risk and needs assessment. I just want to confirm with Senator Sears and or Representative Emmons that that is correct. Okay. So I know there's been some discussion regarding the issue of whether or not expungement, however you ultimately all decide what expungement should or shouldn't be and what it contains. I have no role in any of that. But the issue really has to do with whether or not expungement will potentially impact good risk and needs assessment and sideline JRI. So I'll give you the short answer and the long answer. The short answer is no. And the longer answer is that 23 full states have expungement with a variety of differences, as you heard earlier in the discussion about jurisdictions. I'm not sure I would call them discrepancies so much as differences related to each state, much like a lot of laws and other things exist. What we know is that of those 23 states, 15 of them are JRI states, and all of them utilize risk and needs assessment. So Vermont is not at the front end of this particular movement. It's been done in a lot of areas, albeit with a variety of differences. Regarding the issue of risk assessment, scoring a risk instrument isn't the same as conducting a risk assessment. The fact is the latter, conducting a risk assessment, is way more comprehensive. It requires greater expertise. But what happens is often agencies, and frankly, the laypersons as well, tend to see the two as the same. And so what happens is it results in an over-reliance on the number. One of the things that happens is you see overrides to the score based on policy. You see people throwing things out. You see a variety of problems. The problems aren't with the tools, they are with the implementation of the tools. So when you look at that issue, one of the pieces of misunderstanding that I've heard is that an item from 10, 15, 20 years ago, if it is missing, is going to impact the risk assessment in a substantive way. That is not accurate. There's something that is called risk decay. And you've heard versions of that discussed today. There are a number of different studies and people use different ones, but with the biggest sample that I've seen, even people that are high risk at 6 years are moderate risk, and at 10 years are no different in risk than the average public, than the average person in the public. And so when there are discussions about, oh my goodness, somebody has been offense-free for 15 years in the community, and we have to worry in a big way that there's going to be some significant number of those people that will reoffend, the data just does not support that when we look at the desistance work and when we look at what's called risk decay. Then there's the question of, well, wait a minute, if I don't have that arrest, and to be clear, we're not talking about people who have 3, 4, 5 arrests. We're not talking about people with major violence and a pattern of that over the years. As you've heard, a whole lot of the kinds of offenses that you have in Vermont, and for that matter across the country, are misdemeanors, although that can vary in degree and intensity, of course, and low-level felonies as well. And then you have a group of those high-level felonies that, quite frankly, in terms of recidivism, don't necessarily get higher, but for policy reasons or value reasons, those are cut out of these kinds of policies, if you will, and that's perfectly fine. There's a distinction between what the science says in terms of somebody's recidivism rate and what a society says they are willing to deal with, and that's for you all to struggle with. But to the issue of risk assessment becoming invalid, that I've actually, since the last time I was asked this question, I've spoken with about a half a dozen of my risk assessment colleagues. I've spent the last 10 years working with about 30 colleagues on the development of a number of risk assessment guidelines. And quite consistently, the answer to all of that is no, that is actually a misuse of risk and needs assessment, and why, quite frankly, many advocates are leery of its use. To take something that happened, and I'll pick a number 10 years ago, and to have that person have been offense-free in the community, I'm not talking about an incarcerated individual, offense-free in the community for 10 years, and to then at, say, year 12, that person recidivates, does some crime. It's a relevant issue. The 1 point missing from that previous offense, which is how that would work in a good risk assessment, is not going to make a statistically significant difference. And in fact, you shouldn't be developing your case management plan around 12 years ago. You should be developing your case management plan about what the problem is now, because something is going on now. And unless it's a unicorn, this person who has now committed a new offense 12 years later is going to score on the other domains in the risk assessment. In other words, you're going to find problems in terms of substance use, in terms of general criminal behavior, in terms of employment, in terms of relationship issues, in terms of all of those things. If in fact you're utilizing, and to be clear, you are not, but if in fact you were utilizing a risk and needs assessment that could be completely go off the rails because you are missing this one conviction from 2005, then you're using a bad risk assessment. It's just that simple. So the issue of we can't expunge because we can't then do accurate risk and needs assessment is not accurate. You can, and good case planning involves what is going on with that individual now. And an example of that would be somebody who has done very well for 10 years, has been fine, and loses his job and starts drinking again, or divorces and didn't want to and starts drinking again, or starts doing heavy drugs, or starts doing whatever. What you're dealing with is all of those things, what are called dynamic factors, over the last few years that have gotten you to this point. You're not dealing with the fact that he broke into a 7-Eleven 15 years ago, and I'm making this up. And to be clear, there are certain offenses that you may choose not to do for a variety of reasons, and that's perfectly valid. That's up to the committee, to the legislature, to the state, to every state. But what somebody mentioned before, we need to talk about facts and not supposition. The facts are that the desistance rates are extremely high. And will there ever be a failure? Yes. Can we always find a case to argue our position? Yes. Are there those that even if they're very low risk because of the horrific nature of the crime, we simply don't want to go further? Absolutely. But what you can't do factually is say that the reason for not doing that has to do with the fact that we can't appropriately assess them, or that they have, because they were a risky or higher risk 10 or 15 years ago, we have to assume they will be all the way through. That's just not correct. And so I'm merely separating out that from the fact that all policies that we pass have a number of things. Some of them have to do with the science, and some of them have to do with community values and beliefs and what it is that we are willing to tolerate. And that's perfectly reasonable. I'm merely asking that you don't conflate the two issues, because when you conflate the two issues, you end up weakening both of them. You will end up creating a disbelief in risk and needs assessment, which will not do your system any good service and not do your public any good service. And you will potentially end up not thinking through what some people today have talked about, which are the complexities of thinking about who is expungement relevant for, who isn't. One aspect of that relevancy is their risk for reoffense, which in many cases, despite the ugliness of the crime, may not be very high. But there's the degree of recidivism likelihood, and there's the degree of dangerousness if somebody should recidivate. So it's a combination of those things for folks to struggle with. I'm simply saying that is hard work, it is complex work, which to the degree that we can be helpful, we are happy to, but don't make the wrong assumption that looking at expungement issues means that risk and needs assessment will not be valid, because that's not what the science tells us. That is not the case. And with that, I will be quiet because I know you're running way past time.
Thank you, David. Questions, comments? I don't see anything, so thank you, David. And now Sarah, last but not least. My iPad is running down and I'm going to turn it off. So for Center Alliance and Center Sears, if you do have questions from here on out, just speak up, because I won't be able to see the hand raise. Thank you. Sarah,
Thank you.
welcome.
Good afternoon. Lovely to be with you all today, though I am missing wearing my slippers, which I appreciated while I was testifying virtually. So for the record, Sarah Robinson, Deputy Director at the Vermont Network Against Domestic and Sexual Violence. And I just wanted to start by saying that the network is, in a broad way, understands and supports the availability of sealing and or expungement for certain crimes. And other witnesses have talked about the barriers to employment, housing, and other resources that criminal records pose. And I just wanted to note that in addition, many victims of domestic and sexual violence themselves have criminal histories. And those can pose major barriers to their ability to leave abusive situations and seek safety through economic stability and employment, safe housing, and other vital supports. We testified in support of S7 as it passed the legislature, and we're very glad that you all are looking at these issues over the coming months. And so today I'm just going to highlight a few current considerations, thinking that's in process that we would like for you all to consider over the course of your discussions. So the first is possible future expansion of crimes that are eligible for expungement and or sealing. And as you consider this, we would certainly suggest very slow, careful, and detailed consideration of any crimes that may pertain to domestic and sexual violence. Many of these crimes occur as part of a course of conduct, a pattern of behavior, and they sometimes slowly escalate from more minor infractions to more significant crimes. And because of the nature of these crimes and how difficult it is for victims of domestic and sexual violence to participate in legal proceedings, it's very common for these sorts of crimes to be pled down to lesser offenses. and without careful consideration and additional victim input, we would definitely not support expanding the list of crimes eligible for expungement to include any offenses directly related to sex crimes, domestic violence, or criminal violations of protection orders at this time. Related to that is the process for victim notification as part of the expungement process. It's critically important that victims are notified of expungement petition proceedings, and under current law, respondents of expungement petitions, so the prosecutors, have a duty to notify victims, a victim of the petition if the victim is known to the respondent. If the victim is known, reasonable efforts like a letter and a phone call to the last phone number of record is made so that victims can have the opportunity to offer a statement to the prosecutor or to the court. When expungement petitions are received by prosecutors without knowledge of a case or a previous relationship with a particular victim, or if there is limited capacity for prosecutors' offices to pursue their reasonable efforts to contact the victim, a victim may never be notified and lose their right to have a voice in that proceeding. If or when crimes eligible for expungement or sealing do expand, we can absolutely reasonably expect there to be more crimes that have a victim of record and more victims who will need to be contacted. And related to the issue of notification is that of automation that you have discussed today. And if further automation of expungement or sealing progresses in Vermont, the statutes related to victim notification would absolutely need to be updated. As of right now, it is a highly manual process, the victim notification process, and fairly labor intensive. And the last two items I would like to highlight are possible consequences after sealing or expungement happens. The first is the effect of sealing or expungement on access to victims' compensation for victims. In order to access victims' compensation, victims must produce records that indicate at an absolute minimum that probable cause was found for a crime. If records are sealed or expunged, there does not currently appear to be any pathway in statute to allow for the victims' compensation program to access those records, connecting a victim to a crime. Many victims seek victims' compensation to help defray the cost of things like mental health counseling or other needed supports, and that can happen years after an offense. Sometimes the impact of crimes on an individual's health or their well-being aren't known for years after an experience. And I would just note that in juvenile law, there is a limited provision that allows confidential and minimal records to be held by state's attorneys that associate a victim with a particular sealed offense and date, while all information related to the defendant is not recorded. And so this does allow for victims in certain juvenile cases to access this information explicitly for the purposes of victims' compensation. And so we would be interested in ensuring that victims retain access to this kind of minimal information that might be needed to access victims' compensation as the legislature contemplates further statutory changes. And finally, I will just quickly note the impacts on professional regulations and public protection. Evan Meenan from the Department of State's Attorneys highlighted this as well, but the network would just urge your consideration of the impacts of sealing or expungement as it pertains to public protections and investigations in professional regulation proceedings. There are certain regulated professions that provide access to highly vulnerable individuals, and the ability to access criminal history for certain types of crimes like sex crimes, will remain essential to protecting the public. So that's all I have for you today, but I'm happy to answer any questions you might have.
Great, thank you, Sarah. Questions?
I don't have a question, Madam Chair, but I'd like to just make a comment. We've had a number of witnesses mention when crimes are pled down. And I understand the concern, but I'm concerned that we can only go by what the person was convicted of. And it may be the state couldn't prove the elements of the crime. It may be a deal was made. I'm thinking of cases where, for example, in a DUI where there was a .08, and it is, technically a DUI, but can they prove with that accuracy on the data master? So frequently the state attorney will make an agreement to go down, and we can't always assume that the person, what the reason for the plea deal was. And I really worry that when we look at the crimes that should be expunged, that we go that far. I'm also, I want to make clear that I'm not, advocating that sex offenders or serious domestic violence crimes or any Big 12 crime be added to the list of those that are expunged. So I want to make that clear. And then finally, this whole disagreement over what should be and should not be expungible, that's an important consideration that this committee's got to come up with. And I think that it would be, I'm concerned when I hear that juvenile records, I know not necessarily what Sarah was saying, but what others were testifying to in terms of juvenile records, those have been sealed since, I would suggest, at least the 60s, probably well before those. So I don't know how we can use those as an example of expungement.
I just respond
Yeah,
to one thing.
sure. Go ahead,
Thank you,
Sarah.
Senator Sears. And I was just going, I agree with of crimes being pled down. I think that it's a really tricky and difficult situation. And that was in fact some of the conversation that was happening at the end of the Senate session. I know in-house judiciary around the inclusion of simple assault. There was a lot of data that we were looking at in terms of the number of domestic assaults that ultimately are disposed of as simple assaults. And so I do think that there is going to be a need to dig into some of the data on some of those more common crimes that might be considered for inclusion, future inclusion, just to understand their relationship to any crimes that might be related to domestic and sexual violence.
Thank you. Anything else? Thank you, Sarah. Thank you for being patient. So that concludes our testimony today on expungement ceilings. We'll have some further conversation because we do have to make some recommendations that it might be good at our next meeting while it's fresh in our minds to spend some time on that. Does that make sense to folks? Okay. So let's shift gears, go back to corrections. We have Commissioner Baker with us. He can start us off. There's some issues with DOC staffing shortages. There was a situation, I don't know how many folks were aware of this. Oops.
I'm sorry, I have to leave. I know you wanted to settle on a date. I will do my best if you all select a date to.
But there are certain dates, if you could get those dates that are not workable to Peggy and me.
If I know the range of dates that are being considered.
I think we're gonna try August and September. Does that work for folks?
I'll just work with Peggy.
Yeah.
Thank you.
Try to-
Apologize.
Is there any specific day of the week that doesn't work for you?
No, well, there are a few days where I'll be out of town.
Great, thank you. So as some of you may be aware, with the staffing issue, there was a situation that happened just within a couple of weeks ago of closing down a little bit, one little section of the Rutland Correctional Facility and moving those staff members down to the Springfield facility. Because Springfield was having some real issues with understaffing. And Springfield's a larger facility and higher needs in certain arenas. So that brought up the discussion about the larger issue of staffing, and then if we are moving people around, what the implications of that are. So let's start off with the Commissioner. Commissioner Baker, welcome back again.
Thank you. Good afternoon. For the record, Jim Baker, the interim commissioner of corrections. And I brought staff with me to answer questions. I know your day has been long, so I want to try to make this as concise as possible, but there are a couple new faces here, and some of the staff happen to be in the area today, actually doing the taping of a video for a recruitment video that we're working with Channel 3 on. But there are a couple people that I want you to become familiar with, because as we get into the session, you're going to see them more often. And the first one is Matt Null. Matt is the new director of facilities. Matt comes to us from the Burlington field office, where he was the district manager for Burlington. And he's actually doing the job for the second time as the director of facilities. He is the point of contact, the tip of the spear on trying to manage our way through what is becoming very problematic on staffing. It is not a good situation, and Matt is the point on that. And then Sarah Turcott, I know you've met Sarah before. Sarah is the manager of recruiting and inclusion, and so if we have questions about recruiting, she can answer them. And then I also want to introduce you to Rose Weber. Rose is the new director of the Office of Professional Standards and Compliance. And you're going to see a lot of Rose, I think, probably as we get closer to the session. Rose has been with us for 10 years, and she started out as an intern in the St. Johnsbury Probation and Parole Office. And she comes to us from as the district manager in the Newport Probation and Parole Office. And I think once you get to know her, you're going to find out just how bright she is. And I'm really excited to bring her into the leadership team. I do consider her part of the senior leadership of corrections now, and she brings a whole new perspective to it. And then also, my principal assistant, Rachel Feldman, from her days with the governor when he was the lieutenant governor, and she was his chief of staff. And then Al Cormier is here with me. I don't want you to think I brought an entourage with me that happened to be in the area, but also I want to make sure if you have questions about what we're doing on retention or what we're doing on recruitment, that they can answer those questions for you. So let me start out by saying that the pandemic has taken a toll on our organization, a significant toll. It's been a long 17, 18 months for staff inside the facilities. But I also want to put this in context. We just don't have corrections officers. We have 1,000 employees. We have about 498 correction officer ones and correction officers two. And I'm going to give you the numbers in a minute so you understand the impact of what's going on right now with staffing. We also run these field offices where we have probation and parole offices and administrative staff to support that. And you all know the complexity of the legislation that runs the Department of Corrections. That takes an enormous amount of infrastructure to do. It's just a fact. Classification and furlough and paying the bills and how we staff now. When can we violate someone's furlough? When can we not interrupt someone's furlough? That takes an enormous amount of staff to be able to do that. And so what we're talking about today is we're not having problems finding probation and parole officers. In fact, we had a position open in Burlington. We had 108 applicants. We had positions open in Bennington, and in Bennington we had I forget the number. I know it's here in front of me somewhere, but 49 people apply. That's not where our staffing issues are. When I'm talking about staffing today, I'm talking about the CO1s and the CO2s on the ground inside the facilities. So as I sit here today, we have a total of 91 vacancies between CO1s and CO2s. And our complement for CO1s and CO2s, I told you, is 498. But that doesn't tell the whole story. We also have 53 people out on various levels of leave. be it FMLA. Some are out on relief from duty because of a pending investigation of allegations. We have people out on workman's comp. And we also have a very large chunk of people on military activation, 19. So we don't have access to those 19 folks. And what I'm about ready to say is not meant to try to push this off onto a military activation. But when did this tip? Is when we had the military activation. When we lost those 19 employees, we were balancing things not ideally. There was still forced overtime. There's always been forced overtime inside corrections. And so when the military activation came along, that caused us a major issue. But we also have, 15 people on workman's comp, 10 people out on relief from duty because of investigations, and about 16 people on FMLA. So that's another 53 people we don't have access to. So put those 53 on top of the 91 vacancies we have in the CO1s and CO2s. And that's where we sit as a result of that. The Springfield facility was the first one that we decided we had to move staff. And if you want more detail on this, I'm going to let Matt Nault, who's been managing this on a day-to-day basis and is doing incredible work. Our staff is tired. They're exhausted. I know Executive Director Howard's going to testify. He met with the governor on July 2nd with other reps from VSEA. And the governor has directed me, Commissioner Fastigi, Secretary Susan Young, and Secretary Mike Smith to meet tomorrow afternoon and come up with a plan to come back to the union to try to address what some of their concerns are that were given to the governor. And the governor is expecting us to do something about that. So that meeting will be tomorrow afternoon. What we're trying to do every day is manage the best we can the facilities to keep our employees safe and keep the individuals inside our system safe. And we are at a very, very, very dangerous point. With that said, we're in the middle of summer, and I'm worried about the staff getting a vacation, getting a break, 16-hour days, sometimes 3 and 4. And I'll give you an example of how this plays out. I recently had a disciplinary case where a CO1 at a post in a facility fell asleep at the post. Now that's a big deal. That individual, I would say, panicked and decided to make a note in the log that they did something they didn't do. And that came in front of me. And historically, that is a dismissal. But my point I made to staff is, let me get this straight. We don't have the staff to support them. We're forcing them to work that kind of overtime. And because this person, who happened to be a single parent, fell asleep, we're going to dismiss them? I don't think so. I don't think so. These are the kind of things that are going on. And again, I want to focus on, this is on the security staff. Here's the other thing that's frustrating me. And when I first came in, we're back to where we were when I first came on vacancies, except by 5. The number was 96 when I came. So a year and a half later, we're at 91. I cannot emphasize how frustrated I am about that. And I just want to share this with you, and I'm gonna save time and not take up too much time. I'm just laying out for you what the picture is. So in fiscal year 21, June 30th, July 1st of 2020 to June 30th of 21, we hired 120 staff. 113 of those were CO1 positions. Now, sometimes you'll hear people say that we continue to hire for other positions and not focused on the security staff. There's a lot of promotions that go on, but out of the 120, 113 were CO1 positions. But during that same time, we lost 156 CO1s. Now, you don't have to be a mathematician to figure out just where that takes you. And the hole it keeps digging us in. Now, we're spending a lot of time doing exit interviews and identifying what those issues are. And I've talked about this before, and I'll give you an example to validate what I've said to you before. Some of this lies in the way our leadership on the ground deals with our employees and interact with them. And, you know, the recent employee survey that was done demonstrates this. It demonstrates the fact that people feel like they're not valued. We made some leadership changes at the Northwest facility in St. Albans. In particular, we made a decision on moving an individual from Newport over to Northwest to fill the chief of security. What I've learned in this job in the facilities, the chief of security, the SOS, the chief of security is the person. I mean, they're like the vice principal of the school. They handle everything, schedules, who goes to training, who gets equipment, etc. The person that was there is no longer with us, and I'll leave it at that because it's an HR issue. That individual, Adam Patterson, came over from Newport to Northwest. He has a stellar reputation in the department as a leader. Within a week, 4 individuals who had left called up and said, "Are you there for the long haul?" "Yes, I am. I'm coming back to work." You know, this is what I'm talking about. I understand I have this problem. I understand. I'm not looking to put this on anybody else's plate about who's responsible for that and who's responsible for the way our employees get treated. That's me. But in a big organization like this, cultures develop inside facilities that are very difficult to break. And I'm using that. In the meantime, another employee in Newport called up and said, "I want to come back to work." Another employee in Chittenden called up and said, "I want to come back to work." We're making progress on that front, but we can't keep going the way we're going. And so we have done certain things. We continue to hire. We have a class in right now of 16, but here's another example. We started out Monday with 20. Today's Thursday, we have 16. 4 left. They get and come to realize that this is a very difficult job. Working inside these facilities are incredibly difficult. And I'm not going to belabor this any longer. I'm giving you the statistics. I'm telling you that we recognize what the challenges are. We're doing as much as we can on the recruiting front. We're doing as much as we can as we start to understand why people are leaving. And now we're in this vicious cycle of forced overtime, 16-hour days, 4 days in a row. No one should work like that. In fact, I would submit to you that by the time they're on day 4 of 4 days of 16 hours, they're the equivalent of an intoxicated person. We know what sleep deprivation does. And so we're going to continue to work on this. And we've got to come up with a solution in partnership with the union. But I want to end this by saying this. I talk to a lot of these employees on a regular basis. This week, I've had conversations with 2 or 3 of them privately. They don't feel like they're valued. And I got to tell you, that's just not on me. That's on everybody. And, you know, I sat in on the Vermont Criminal Justice Council meeting yesterday. This is throughout the justice system. State police tested 3 weeks ago, 3 people showed up. Police departments can't hire. I understand we have to have a more fair and balanced and inclusive justice system, but we got to understand that these people are not robots. And that when they're trashed publicly, or they're talked about, or they're not valued, or they feel like they're not valued, that has an impact on my ability to be able to retain them. I'm not pushing that blame on anybody. I'm simply saying that my message today is that we're in this together, and we all got to be in this together. And pointing fingers at people or making accusations are not going to help us get to where we need to be. I am thankful for the people that are in these facilities that are hanging in there and doing this work. And so I'm going to leave it at that. I do have staff here. I don't want to take a lot of your time up by bringing them up. But if you have questions about recruitment, you have questions of Matt, of what we're doing, Matt is on the ground almost every day going to these facilities now and talking with staff. And we're working through every crisis that comes up. We're working through it to make sure we got staffing. I need about 3 months to be able to stabilize and get these new classes out. We've got a class in now. We're going to run 2 more classes by November 1st. And we do have people applying. But if we can retain them, we got to do a better job of retaining. So I'm going to leave it at that, Madam Chair, and I'll open it up to questions.
So I remember, Commissioner, you saying back, it's been in December now, maybe January, that we don't have a recruitment problem, we have a retention problem.
Yes, we do.
So I'm assuming that still hasn't gone away, but I'm wondering if we do have more challenging recruitment arena than we used to, because of what you just stated with the culture change that's happening nationally. And it's across all of our law enforcement, public service, and correctional officers. And is that impacting our recruitment as much as it
You know,
was?
interesting enough, and I certainly would have Sarah talk about the numbers, but we've really focused in on, we're doing Facebook ads that we're paying for. We're really using social media. We're leveraging that. As I said, they just came back from shooting you're going to start seeing at the beginning of August on Channel 3 ads during the news, advertising for the jobs. We've actually seen a bump in the last couple of weeks in applicants. The challenge is we started the background process. This class, I think we ended up washing out 15, is that the number? 15 people as part of the background investigation. 3 of those 15 had some very disturbing stuff in their personal social media stuff, not the people we want working in facilities. So we have that coming in. I don't think we've really changed that much. One of the strategies we're going to use is, we had 108 people apply for that probation and parole job. That means 107 people that we're going to contact to offer them opportunity as an entry into corrections. So I'm not sure we're seeing that yet, but I will tell you it wears on the staff in the facilities.
Jim, thanks. Alice, can I ask?
Go ahead, sir.
Jim, I'd like to understand both the Bennington and the Burlington P&P positions.
Yes.
I thought that in order to work at P&P, you had to have worked in the facilities at some point. Is that not true any longer?
So there's a lot of entries into our department, Senator, through probation and parole.
Okay, so they're not necessarily 100 people that worked in the facilities applying for the Burlington job.
Correct. You know, and there's some second, along these lines, Senator, going back to my earlier testimony today, there's some second and third reactions to the fact that we're bunkered down to try to keep these facilities going. So for example, I have 15 community corrections officers positions open that play very much into what we talked about this morning. But if I open those 15 positions up, you know what's going to happen. They're going to come out of the facilities. So I can't fill those right now until we get this situation stabilized.
Thanks, that's helpful. I appreciate the problem, and it's all over. It's not just with corrections, but that's a tough job, and hopefully we will consider some upgrades to the pay and working conditions for these folks.
So I have a question. One thing that it was constantly testified during the legislative session, particularly to my committee, in terms of recruitment of correctional officers and the culture and the training. One of the thoughts was to really work with the folks who are being recruited and get them into the training prior to spending any time within a facility, because the thinking is if they spend any time within a particular correctional facility, there's a certain culture there. They bring that into the training You never let it go. So let's get them into the training first and then put them in a facility. Have we made any of that shift, or are they still spending time in our facilities?
They still shadow on the average about a week ahead of time, just to give them a flavor of what that is.
Mhm.
I'll be interested in the exit interviews of the people that left this week. I know one situation was a young fellow was on the verge of, was he going to re-enlist in the military, or was he going to do this? And he got to day one, and I think he just made his mind up that, you know, he decided to re-up in the military. But to your point, Representative, I will tell you, and I'll be visiting with the class next week. I'll get up there to see the class. The last class I went and visited, and we pick up on this from the exit interviews. And when you talk about culture, people are so, staff out in the field are so frustrated over the years about the repetitiveness of what's going on here, that somebody will come new to the facility and they'll be told, hey, we're not going to get to know your name until, you know, and I talked about this before. And I asked the class that day I went, you know, 2/3 of the class said, yeah, I was there for a week. And that's exactly what was said to me. That's just not the way to treat people. And so, you know, we've sat the superintendents down and told them that we have to do a better job of welcoming these people into the organization. Now, the challenge we have now is, and I just asked Rose today to follow up on this from a conversation I had with a couple of the bargaining unit folks over the last week, is that now we're in this vicious cycle, and we don't really have the time for our FTOs to spend with new folks coming in. And, you know, this is another, you know, a third down the rail, result of this staffing issue that and challenge and crisis that we have.
Questions? Butch?
I do, but before I have a question, I want to comment on what you just talked about, or maybe have a question for you on that. You just talked about current employees basically chasing off current recruits by the attitude of saying, you know, we don't want to get to know your name, but yet those same employees are complaining about working 16-hour shifts 4 days in a row. That seems just terribly counterproductive within the organization and within the employees. Just thinking about it, it was just a
Representative Shaw, I appreciate what you're saying, and I'm not defending them, but I am starting to better understand just how frustrating this is and the damage that's being done to individuals.
And I get that, Commissioner, and somehow, good luck getting that message out.
Well, let me assure you the message is out. Okay.
Cool. So, but now to my question.
Okay.
You were very aggressive in bringing folks back from out of state, and had the opportunity to bring folks back, but now you're in this employee crisis. What's that doing to the out of state bed count?
It's still where it was. I probably should have this number off the top of my head, but I've been dealing with this staffing thing so much that I'm sidetracked with that. I think we have a trip coming back with some folks that need to come back, only because programming and the kind of things that need to be done back here. Let me just tell you this, these conversations got so intense around me a month ago that we considered sending people out of state.
Yeah, I guess that's, yeah.
And
So
I know the political ramifications of that, and I know how hard that would have been for people to hear. We actually started the process of medically clearing people to go. And I had taken a couple weeks off, as some of you know, and I was going to deal with it when I got back because I didn't want that on Al's lap. But this is another statement about what's in the system. We thought we had to get probably somewhere around 70 to 100 to move to have any impact. Well, you could only clear 35 of them medically. That's the kind of medical challenges we have in the system, right? So,
but at the end of the day, it is affecting your out of state population.
it's affecting our ability to be thinking about what we're going to do there, right? Now, the second thing that we did, that we actually explored the possibility. Is there some company out there that has traveling corrections officers that are similar to traveling nurses? These are the things that we've been doing to try to figure this out. And the answer is no. I went to Core Civic, And we had a conference call with them. And I tried to talk them to get into the business, but it's not in their interest to get into business. Now, I understand the whole downside of that, right? Privacy, that's not what we were trying to do. It's similar to, what happens in the medical field, especially at the height of the pandemic and traveling respiratory therapists, nurses, PAs and so on. That's the kind of stuff that we've been trying to deal with.
Thank you.
Do you know offhand, or one of you folks, Al, or some of you other folks know what your population numbers are today? Are they still stabilized, or are you starting to see them go up? now
We're
with
at
the COVID?
1297 today.
So that's up about 100,
Detention is up,
because you were around 400.
correct. The women are 99 today.
And they were down to about.
I saw them as low as 82. 85, 82.
So the courts have opened up, and that's where they're starting.
Police departments are becoming more active. The feds are becoming more active, so some of the detainees end up being some of the Fed detainees.
Questions?
No, I'm just thinking.
Anything that the DOC folks that you brought in? Have us back? Anyone want to share anything?
If there's questions after, I know you've had a long day, and
Yeah,
I don't mean to
great.
bring all them up this, because they were prepared to talk about exactly what we're doing. But again, I can have Rachel summarize that for you and get it to the
That would be
committee.
great.
Okay,
That'd be great.
thank you.
Howard, the SCA, welcome.
I didn't bring my entourage. Tom Abdullah is on YouTube watching, and Senator Luzzi is doing an arraignment and watching at the same time.
Well,
Probably
he's
on the
good at
phone.
He's probably good at multitasking.
Good afternoon. For the record, I'm Steve Howard. I'm the Executive Director of the Vermont State Employees Association, and we represent the CO1s and CO2s and all of the frontline folks who work in the facilities and who work in the field in the Department of Corrections. I want to just begin by sharing some statistics with you that I know you've heard me say before, but I want to remind people. Those of us who are lucky enough to live to the average life expectancy can hope to live to age 75. A correctional officer's life expectancy is 59. They have higher rates of divorce, 50% rate of divorce. They have all sorts of medical and emotional impacts from the work that they have. PTSD rates higher than veterans returning from war. They work in very difficult conditions consistently over time when the facility is well run and fully staffed. So this doesn't get easier when it's not well run and it's not fully staffed. It gets much worse. So to prepare for this testimony, folks will know that I've said this in other committees that I've testified before, but I always put out my phone number, my cell phone number, to all of our members who work in the facilities, and I say I'm going to testify, and what would you like me to share? And I will tell you that I brought some of the emails from me that I got today, but my phone blew up yesterday with long, well thought out messages from people who wanted me to share a message with you. And the first thing that they wanted me to say is that it's not a result of the economy. We're not in the same situation as McDonald's trying to find staff. It's not the same as that. It's not because of COVID. What they wanted me to say is that the reason that we're in this position is because of the culture of the Department of Corrections. And there's many aspects of that that are really, I think, important to share. But first, I want to say that, let me just begin by saying that we are very grateful that we had the opportunity to meet with Governor Scott. And we stayed an extra half hour longer than we were supposed to. And he went off script and put his talking points aside and actually asked real questions and really was engaged. We would not have gone to the governor of the state of Vermont if we thought the issue of the staffing crisis was adequately being addressed at lower levels. This is an emergency. This is a crisis. And while our members in the VSEA have been trying to sound the alarm, we have not, until we met with the governor, felt like we have gotten any kind of an urgent response to this problem. People are sleeping in their cars. They're making mistakes at the end of 16-hour shifts. 16-hour shifts with some of the most violent offenders we have ever had in Vermont's prison system. These are not easy people to manage. And they're working 16-hour shift day after day after day. What you hear when you travel around and go to the facilities and you go to the probation offices is, my wife is telling me you either pick this job or your family. What's that choice for a Vermonter working, trying to do their best in a correctional facility, trying to support their family? Their spouses are saying, you either find another job or I'm leaving. I heard that over and over and over again. We are treating these people like animals, and it is unfair and it is wrong. And so I am very pleased to hear that the governor is taking this seriously. And I think we have to keep the pressure on to find the solution to this problem. Now, what are some of the problems? I'm going to just walk through a few of them. First of all, I just want to give you an example of what we're up against. Vermont is sort of an island. If you're a correctional officer and you live anywhere near the border of New Hampshire, Massachusetts, or New York, you can get a much better retirement in any of those states than you can in Vermont. Vermont's pension system is 7% lower than the national average. You can retire after 25 years or 20 years of service in those states, not in Vermont. And I have to tell you that one of the reasons why we're at this point today is because of the discussion around the pensions that occurred in the last legislative session. Some of our most senior and experienced staff ran for the hills. And there are more who have their paperwork filled out to see how the task force on pensions completes its work. And if it doesn't go in a way that they think is fair, they're going to go too. That's not anything new. I've talked to the commissioner about that, shared my concern about that with the legislature. That issue is a very important issue to watch. We're going to have a major, major problem in this department in particular, because it's not just about having bodies in those facilities. It's about having experience in those facilities, having the experience to know how to handle things, how to de-escalate things, how not to react in a way that's going to escalate a situation. And we are losing talented people because of the discussion around the pensions, especially as you compare it to the states around Vermont. Massachusetts, New York, and New Hampshire all have better retirement plans than the state of Vermont offers their correctional officers. Staff members are routinely assaulted. They have feces and bodily fluids thrown at them regularly. They're forced to work these inhumane amounts of overtime in 100-degree weather in unair-conditioned buildings. Now, that's not only unfair and inhumane for the folks who we represent. That's not even humane for the offenders. 100-degree weather in brick oven buildings, wearing sometimes full PPE in very uncomfortable uniforms. It is just a symbol of how disrespected and devalued, as the commissioner said, these folks feel when they go into work, facing the difficult work they have. And the building is so hot in the summer and so cold in the winter, they feel like nobody cares what happens to them. As I said earlier, I talked a little bit about the impact on families, but I just want to focus you on this picture because I was at Southern State not too long ago. I was up there at third shift with the president of the union. And as we walked out of the facility, we were able to leave around midnight. We were leaving, and we looked over, and there were 2 trucks parked in the parking lot with COs sleeping in their trucks. Why were they sleeping in their trucks? Because they didn't have time to go home before they had to come back to go to work. So they're sleeping in their trucks as employees of the state of Vermont. And that is unacceptable. Vermonters do not think that's acceptable. And so neither should any of us. Now, this is going to make the commissioner upset, and I know he's going to get mad at me for saying this, but I'm going to say it because I don't feel like pointing fingers I agree with him. Pointing fingers is not helpful. But I do believe you have to keep it real. You have to be real. And one of the big problems in the culture of corrections is the disconnect between the managers in central office and the policies and procedures that they put out and what happens on the ground. There's also a huge problem disconnect with the folks in the superintendent's office and the folks who are actually at a post. There is a huge problem there that needs an enormous amount of attention because it's part of the reason why people are leaving. They don't feel valued, they don't feel heard, and they also don't feel anybody has their back. And the legislature, I have to say with all due respect, because I love the legislature, a lot of it is the amount of change that we have tried to foist on this system without acknowledgement that we don't have the resources to match, that we don't have the staff to match. And it's a feeling of frustration because so many of our members agree, some don't, but many of them agree with the reforms that the legislature's made, but we don't have the resources to implement them without them being onerous and difficult on the people who are already working without enough resources. So if we want to have these facilities be rehabilitative, they've got to be upgraded because the buildings are in terrible condition. They've got to be humane, but we also have to have the staff resources to support the goals that the public and the legislature and the governor have for the correct criminal justice system. We don't have those resources now. And so it's a giant source of frustration because as they sink, they feel like they're getting thrown more and more work to do, more and more responsibilities on top of what they already can't handle. I do also want to say that, you know, we are a little bit of the middle of a battle, I think at the labor board with the department over some reclassifications. But there is a difference in the pay between those folks who work in facilities and those folks who work in the field. And that is one reason why, if you opened up those CCO positions, you would have a lot of people from facility supply, but you'd also have better schedules. You'd have a lot freer, more reliable life. You wouldn't have as much uncertainty like what you have with mandatory overtime. You never know when you're going to be able to leave the facility. But the pay difference is a big difference. It's particularly a problem with our CCOs. When you're for CCO in a facility, you're paid less than you are a CCO in the field. We're in the middle of a battle about that. We hope to win that. That will have a major impact if we win. But that was a mistake that management made, and it's having an impact now on the morale of the staff in the facilities. So I think what I would conclude with is, I think I've said this before, but it's sort of consistent with what I was just testifying to. I don't think the commissioner would disagree with this. I don't think you would. But if you want a correctional system that is truly rehabilitative, the first place you have to invest is in the staff that work there. That's the most important element. Just like in a school, you have the best school building in the state, but if the teachers aren't really great, you're not going to have good outcomes. If you don't compensate them and treat them well and build the level of experience and teamwork that they need in order to run that facility well. So the first thing we have to do is dramatically increase the both financial and educational and other internal managerial support for the people who are working there so that they won't leave in the numbers that they're leaving in. So I would just say that if we want to build the correction system that you want, you're not going to save money doing it. This is going to cost you more money. We're going to have to make a commitment as a state to invest more money because we want better outcomes. We don't get better outcomes by cutting spending. We get better outcomes by making strategic investments. The best investment you can make is in the staff who work in these facilities. That is, I think, a major component of how we attract and retain the staff at DOC. And with that, I'm happy to take any questions you might have.
Thank you, Steve. Questions, comments? Representative Wood?
Steve, I'm just wondering, you referenced sort of the disconnect between central office, policies and thought process and stuff and what really happens at the facility level. And what are the kinds of things that you think would be helpful in order that those two things might align better?
Well, I think the central office managerial staff need to spend more time working in the facilities. And I've made that suggestion to the commissioner, that they actually be assigned to work in the facilities. In this crisis where we had to move folks from Marble Valley over to Springfield because of the real emergency in Springfield, which by the way, landed like a bomb in Rutland. I asked, are we going to reassign anybody from central office who has experience in the facilities? And that I kind of got, well, we'll look into it. So I'm hoping that that actually will happen because I think it would it would be a beneficial thing for both the managers to see what's really happening on the ground and how their policies and procedure are landing. And for the CEOs who are struggling to keep this system together, that the managerial staff is right there by their side. We've got to get that disconnect. But the other thing I just want to point out, we had a big bill this year that was in your committee on corrections. It had some elements in there that we were very much opposed to. Drug testing at a standard more aggressive than the state police.
We took that out.
We took that out. But that was an example of what the administration proposed. What was not in that bill was an answer to the question, what happened in that facility that there were 6 superintendents in 7 years? 6 superintendents in 7 years. Where are those superintendents? Where are they now? They still work for the Department of Corrections. They're in central office. Our members want to know why. They want to know why that happens. The message that you'll hear, and I'm just going to be real, be more polite about how they say it, but the message that you hear on the front lines is screw up, move up. And that's what they think happened in that facility, and they think it happens over and over again with the superintendents that they are working with. If you screw up, you move up. You're in central office. That should have been a major part of the investigation. What's going on in central office? Who's there? Who are the managers there? How did they get there? Where did they come from? What's their background? Were they the folks who were running the Chittenden facility when all of that stuff that was alleged in that article took place? And what did they do as managers when members of the VSEA came to them and said there's something happening here? Those are questions that the legislature didn't ask. The management didn't put in their bill. Downs-Racklin didn't really include in their study. They did have 5 pages in that study about the retention problem. There was very little, almost nothing in the bill proposed by the administration to solve the retention problem, which is why we are so happy that we've gotten the governor's attention. And we are so happy that he has taken this seriously because we hope that this will actually result in some kind of change. And so what I would ask the legislature to do is to really pay attention to that, what happens in that meeting tomorrow and what comes out of it, and to help keep the pressure on the administration to dramatically improve the working conditions, to improve the relationship between management and the staff, and to compensate them in a way that shows the danger and difficulty of the position that they're in, so that we can attract more people and keep more people, and let people go to their kids' Little League games, let them go see their kids play basketball, let them not have their wives say, I want you to choose between the job you need and the family you love. That's what's happening now all throughout Vermont. You hear it at every single facility, at every single shift throughout the state of Vermont. And I know none of us think that that's a fair thing to do to anybody. So it's a sober message. I'm not trying to point fingers, because I will say this is not something that's all on Commissioner Baker's back. These are all arguments that we've been making 2 or 3 or 4 commissioners back. That's how serious we've just gotten to the point where it's an emergency, it's a crisis, and the whole system is beginning to collapse.
Questions? Yes.
Thank you very much.
Thank you. Thank you, Steve. It's been a long day, but thank you. Thank you, Commissioner and DOC, for coming in. I'm sure we're going to be revisiting this issue. So, folks, I know it's getting late and folks have to go, but is there anything that's coming to the surface for folks for agenda for next meeting in August? Anything really coming to the surface? I think we work on the expungement, try to get that, raise the age. There was talk in one of our previous meetings about looking at really looking at the juvenile justice, and if there's no Beckett. So that could be connected with race, not connected, but that could be part.
Right, I understand there's continues to be further delays.
With Beckett.
Well, with the proposed home
Mhm.
and the communities.
There.
May I add that if we could get somebody from Ledge Council so that everybody's really informed as to the differences between youthful offender statutes, raise the age, and the other, because there's a lot of confusion in the juvenile system. And I've heard people referring to, even in here today, to the youthful offenders as treated in the family court, but they're really, it's different. And so I hopefully, Ledge Council could just go over briefly the differences between the different statuses with raise the age and youthful offender. There's a lot of confusion about that.
So we can do that, because I'm gonna work with Michelle. So we'll put it on.
But also,
And
I've heard the
can I
same
add-
thing about Beckett.
And also what?
Yes, I was just going to add, could we have information about the kids who are going to Beckett and what their status is, their judicial status is versus the any other behavioral status that's non-judiciary? I'm just trying to sort out who's who in the system and then how they're dealt with.
Well, and also, I mean, I don't know if this is the Child Protection Committee or this committee, but you should also look at what David Diamora brought up about the efficacy of sending kids out of state to, because I think we send the bulk of our
I'm
kids
totally
out
with
of
you
state.
on that.
I
I
was
wrote that down and I
actually,
think,
yeah,
yeah, listen, Dick, I think it's probably both committees. If they're sent out of state because they've been adjudicated in some way, or if they are sent out of state just through DCF, I think both committees need to hear that information.
I think the numbers are in the
Well,
hundreds.
The
Yeah,
numbers-
I don't know. I don't know.
The numbers. Yeah. Michelle, I hope you. So we can do that next meeting. The other thing, there was an auditor's report that is due in August about transports of mental health and DOC.
You know, we're still waiting to hear from the auditor.
And then get an update from DOC and BGS about their visit to Maine for the reentry program for the women, because that will help us understand the process the following month of looking into replacing the women's facility. So that seems like a pretty full plate. Sure.
I'm just wondering, going back to expungement and sealing, I mean, what's our next step?
Well, if you look on, Act 58, Section 5, that explains what our role is. We need to make recommendations on how to streamline the process, improve the process, what crimes should be eliminated. There's a list right there. So that's what we should work on.
Yeah. That would.
Any recommended legislation that should be introduced?
I think the testimony was very helpful today. I also think that there's a fair amount of work to be done amongst the folks who testified to flesh out the issues. See where there's agreement or not.
So would it help, Maxine and Dick, for us to put that on our agenda for next month, that would push those folks along to talk?
Yeah,
Open to suggestions. Yeah. So I think we have a construct of a pretty heavy We're meeting in the State House. Let's meet at 10 o'clock. Because some of us have to travel. Okay, let's meet at 10 and try to plan to 3 o'clock.
And what's the next date?
So I know that you're on Elkhart, Center Alliance is on Elkhart, but it's every other week. Okay.
And the pension task force isn't meeting the week of the 9th. So that opens me up for any day that week. And then I'm just tied up to every other Wednesday in August.
How about the 11th?
Yeah, I can do the 11th.
Of August. That works. Wednesday, the 11th. August 11th, from 10 to 3.
I won't be here, but I'll get Mike to cover.
Okay, that was Peggy, right?
Yep.
And then what we'll do for September, I would really like to do for September, if possible. Depends on the week for Elkhart. And you're gonna be meeting on Wednesdays.
So yeah, we're meeting September 9th, which is a Thursday, and then the 15th and 22nd. And then October, just for full disclosure, I'm gonna be able to make, my wife and I are having our second child in October, so just,
Yeah,
we're due at the end of the month, but you
never
it's up in
know.
the air.
You could be at the end of September
Yeah,
or the 1st of November.
yeah.
Representative Emmons, we're still live. Is that okay? Or do you want me to go off live?
I didn't understand.
I said we're
Oh.
still,
Oh, okay. I think we can go off of live because we're
Okay.
just trying to schedule.